Welcome to Case by Case, a podcast by Luke and Calum of Xyloploid Zadkovich. It's great to have you with us today listening in, and I welcome my colleague in this podcast, Calum. How are you?
I'm good, thank you, Luke. I'm good, yeah. Thank you to everybody listening as well.
Calum, I noticed the post that you put up launching this podcast on LinkedIn, which I really liked. I thought, do you want to just give a little summary of what this podcast is about from your perspective? I really like your description about your enjoyment of case law.
Yeah, I think so. There's a lot of legal content available, and if you want to find out the decisions of any case or what any case means in a short form summary, then there's a lot of places that you can go and look for it. But really, there's nothing quite like going to the case law itself and reading the judge's thoughts in their own words. And it's something that I really enjoy doing. It's one of my favorite things about being a lawyer, and it's something that I studied history at university and then came to law through the conversion course, where you're just learning kind of case the case ratios without really engaging with the cases in a huge amount of detail. So it's actually something that was sprung on me only when I started doing kind of research tasks as a trainee, and it was one of the parts of the job that I enjoyed the most, was just really reading these cases in the judge's words, the way that they articulate these arguments. They kind of sift through all of the excess facts and hone in on what's important, and write in a really crisp, clear, logical way. Something I've always enjoyed, and we've discussed before various cases, and I think we both have a similar approach in that we both like to go back to the original source, read the case kind of cover to cover, if you like, and we've had some great discussions about cases. So we thought, why not share them? Why not have the discussions in a more open forum? And the kind of the way that we've decided to do it, and the way that we've been doing it so far, is that we each read the case, and then we just jump straight onto a call, and we hit record, and we just get our organic thoughts without too much tinkering around the edges to make sure we're saying exactly the right things. You just have exactly what's on top of our mind when we're reading these cases.
Yeah, well said. I'm enjoying it too, and I'll be honest. I haven't had as much of an opportunity as I would like over the last few years to sit down and just read case from cover to cover, and have that discipline of reading every single word in a case, really unpacking it at a granular level. I think with some of the responsibilities that I have in the firm and caseload and all of that, you get into a habit of being more mechanical in your approach, and looking at a case for the ratio, for what it stands for. How does that help your case? How does it hurt your case? What are the ways around it? If it's something you don't like, how can we distinguish it? And then being quite more mechanical in the practice of law. And what this podcast has enabled me to do is to really read the cases for their own sake, rather than what's the purpose? What are we trying to get out of this case for a client or anything else? Just actually reading it and thinking about it in a more broad way, and then thinking, well, how would clients more generally find this case relevant to them? How could it be of interest to them? How might it help their business or what they're doing? And then jotting down a few notes and then kicking it around with you. So I know we're still early in the process. Let's see how we go after a few more, but I'm enjoying it for now.
Exactly. And this is actually a very good one for that, because I always find that Males's decisions are really well written. Which is, it's kind of absurd for me to say that a Court of Appeal judge's decisions are well written. Of course, they're well written, but Males in particular, I really like the way that he articulates his thoughts, and he's not afraid to shy away from just stating something very plainly, as he does a couple of times in this judgment. And those kind of give me little moments of joy when I'm reading a case law too. The judge, effectively sitting down one side and saying, no, this is very simple.
Well, it's funny you say that, because I can remember, I must be going back on 15 years ago or something like that, and don't hold me to the exact date, but there or thereabouts, and having Mr. Males, QC as he then was, on an arbitration as a sole arbitrator. And I was kind of used to the more, I wouldn't say laissez-faire, that's putting it too softly, but the ability in arbitral tribunals to get some play here and there on timings. And I'll never forget the first arbitration that I had with now Lord Justice Males as an arbitrator. He would not, he was very strict, let's just say, on timings, and approached it very much like a court judge would.
Good practice for his later career.
Exactly. So, okay, let's get into this case today. It's a Court of Appeal decision, English Court of Appeal decision, the decision of Septo Trading and Tintrade Ltd, recent decision in May 2021. Lord Justices Moylan, Males and Phillips gave the judgment. Lord Justice Males gave the leading judgment, and the two other justices agreed and concurred without really further comment. It's just on Septo when the name popped up again, Calum. I don't know if you had this reaction, but I remember the first instance decision coming out shortly after the lockdown. And it's one of those cases that's stuck in my mind as being kind of around the start of the pandemic. Time. And to now think that we are dealing with the Court of Appeal decision on that decision. Time has moved on.
I like that as a frame of reference for the passing of time, where a Court of Appeal decision, hence.
Yes, yeah, it's exactly. So I was just thinking, do you want to give a summary of the facts of this decision? Probably. I was thinking spend more time on the legal principles on this and keep it quite high level on facts. But, over to you.
And I think the facts are actually quite straightforward, or at least, as I've said, the way that they've been presented by Males at least is quite straightforward. So you have Septo, who are the buyers, and Tintrade, who are the sellers of a cargo of heavy sulfur fuel oil. And the contract that they'd agreed, as is extremely common in shipping, commodities, trading, you effectively have a base document with the majority of the terms, and then the core recap, if you like, or effectively the key terms agreed between the parties. And the recap, again, as is extremely typical, refers by incorporation, or it incorporates by reference the body document, which in this case is the BP terms. And here the question is, was there a conflict between the recap and the background terms, the BP terms? Effectively, what had happened was that in the recap, it said that there was a load port survey to take place to assess the quality of the cargo. And the recap said that the result of that load port survey was to be binding. It said the words "result to be binding." And the recap also said that where the terms of the recap were not in conflict, the BP terms would apply. And then you turn to the BP terms, which say that the load port survey is binding for invoicing purposes. And surprise, surprise, the load port survey says everything is fine, but in fact, it later transpired that the cargo was slightly outside the contractual specification. So you then have this dispute, and the dispute was essentially whether the load port survey was binding in entirety, or whether those two terms between the recap and the BP background terms should be read together, such that the load port survey was in fact binding, but it was only binding insofar as it was relevant for invoicing. And obviously the seller is trying to say that the load port result was binding, and the buyer is trying to open up this dispute so that they can bring their claim.
Absolutely. So it's a case of inconsistency between the specially agreed terms, and I'm going to call them the printed terms. I think that's the phrase that's used in the decision, but we know them as sometimes, that the head charter party or the prior charter party, or kind of other general terms and conditions. But it's really that point between having a recap, which is specifically agreed, and then by incorporation pulling in a bunch of other terms that have not been specifically agreed on that trade. They may have been specifically agreed previously, or they may just be general terms and conditions of one of the parties. And this, for our listeners in shipping, in commodities trading, and in other general commercial contract settings, will be very used to this. This is not an unusual case at all. And from our perspective, it's an issue that comes up time and time again, because often what happens is the traders or the chartering personnel, if it's in a shipping context, they're focused on the specially agreed terms, the recap. They're on the phone, they're talking about price, they're talking about where the discharging port is, where the loading port is, what the quantity is, what the type of vessel is, all these things, the quality of the oil in this case, what's going to be the process for deciding on the quality, what's the certification regime, which is what this case kind of goes to. But the trader is focused on the recap and the key main terms that are being agreed. I dare say that many a time they don't even look at the printed terms because they are of the view, from a commercial perspective, that as long as we're agreeing it in the recap, it doesn't matter what's in the printed terms, it's going to be overridden by this. And that commercial approach to this, I think, is actually reflected in the law, as we're going to explore here. But it's an issue that comes up when we get contracts that are in this composite format. We see it time and time again.
Yeah, and I think it's, as you say, we'll go into the discussion. Probably now we'll go into the discussion. But what I think was perhaps where the law was before this judgment. And I'll be interested to hear your view on this. Whether you think this has shifted the law in any direction, or whether this just kind of restates the law as it is, with application to the specific facts in this case. But certainly where it was in the Pagnan and Tradex case, which is referenced in this judgment, which is an older case. Let me just find the.
I think it's 87.
Yeah, that sounds right.
1987. Yeah, Court of Appeal decision too. English Court of Appeal.
Yeah, and it was Bingham who gave the leading judgment there, I think. And he is very clear that the printed terms are part of the same contract. And I think I've seen that phrase used before in a number of a number of occasions. If you're trying to argue that a term you don't like in the printed terms is being kicked out because it doesn't fit neatly with a term in the recap, then people can turn to Pagnan and Tradex and they can say, no, these are all part of the same contract, and they almost have the same contractual effect because it's all part of one agreement. And that argument is slightly at odds, as you say, with the way that it seems like these contracts are all drafted, and the way that these contracts are entered into, which is effectively you have a heavily negotiated recap, and then effectively a checkbox for do you accept the terms and conditions, which we all know that you just click accept, and that's almost how I feel like the printed terms tend to form these agreements.
Yeah, and that's a key one actually. That issue of is the printed terms do you just consider it part of the overall contract when you're dealing with these inconsistency arguments, or do you approach it more in the way that Mr. Justice Males, or Lord Justice Males, does here, in first looking at what is in the specially agreed terms, and then once you establish what that term is and means, you then put it against the printed terms. It's this issue that was actually debated as to where to start with the inquiry. Do you start looking at the whole set of terms, specially agreed and printed as one, or do you start the inquiry at the specially agreed terms? And Lord Justice Males approaches it very much from the perspective of looking first at the specially negotiated term first, and then stacking that up, and how does the printed term affect that that specially agreed term.
Yeah, exactly. And this was one of the moments that I quite liked in the judgment, where you could almost sense the frustration of Justice Males with the argument where he was saying, okay, so we need to start by working out what the recap means. And then the argument from the other side, or the argument obviously from the party trying to say the recap and the printed terms should be read together, was, well, you can't analyse what the recap means unless you also read that in the light of the printed terms. And Mail says, well, it's necessary to start somewhere. So, which is totally fair enough. You have to at least start. You have to work out what some of it means. The other thing I'd say is there's a bit of guidance in the recap itself in this case, because the incorporation of the BP GTCs, the printed terms, is expressly where not in conflict with the recap. So you have that primacy of the recap within the recap itself, which gives some guidance, at least to the court, in saying, okay, well, we need to see if there is a conflict. Yeah.
Well, I really like the judgment in the way that it traverses, if I can say this about a court of appeal judgment, but I really like how it traverses the principles that are at play, starting with Pagnan and Tradax Ocean Transportation, then moving on to Alexander and West Bromwich Mortgage, another Court of Appeal decision, and goes through the various key elements in this inconsistency inquiry, and then pulls it all together. And I think it's paragraph 28, which I'll get into a bit later, but I really like that paragraph because it pulls all the principles together and then puts it into one statement. So I know for myself, the next inconsistency issue that I have, where it isn't just this is clear to me, I move on, but one where I'm really looking closely at the point, I'll just go to that paragraph because I think it pulls it together so nicely. But before we go to that paragraph, should we just touch on some of the principles? And the first quote that I pulled out of this decision, which is a quote from the Pagnan decision, and this is quoting Lord Justice Bingham. It is not enough if one term qualifies or modifies the effect of another. To be inconsistent, a term must contradict another term or be in conflict with it, such that effect cannot fairly be given to both clauses. It's this concept of qualifies or modifies that is picked up in this decision. It's picked up in other decisions as well. And that's an important concept to keep in mind when comparing the two terms.
Yeah, and I think that's really, if you're kind of tweeting this case as in as short form as possible, that's really the distinction that this case drives home. Does the printed term modify or qualify the recap, or is it fundamentally inconsistent? Exactly.
And then Lord Justice Wolfe, he uses the phrase supplemented. It's almost this idea of, can the two terms sit nicely next to each other, supplementing each other, qualifying, modifying each other, or are they just inconsistent with each other? Do they conflict? Do they contradict? And the other phrase from Lord Justice Dillon is, when posing the rhetorical question, what is meant by inconsistency? It's when two clauses cannot be read sensibly together. And I think that's another good way of looking at this.
Yeah, I totally agree. And I think that this is where I would say that this judgment doesn't really affect that law at all. It just applies it neatly and quite sensibly, I think, to the facts here, particularly the kind of more granular way, or the more granular facts when you look at exactly how the payment mechanics were supposed to happen under this contract. Which maybe we should just talk through now that I've raised it, because the argument for on the side of kind of supplementation or qualification was that you've got one clause that says the load port survey is to be binding. That's the recap. And then in the printed terms, it says it's to be binding for invoicing purposes. So the buyer, who's trying to open up this dispute and trying to say that the load port survey is not binding, says, look, you can read these two together. You can say that the result is binding and give effect to the recap, but you just qualify that and say that it's actually binding for invoicing purposes. So as a buyer, we have to pay first, and then subsequently we can bring a claim. If we disagree with the survey, we can get further surveys and we can bring a claim. But for invoicing purposes, we're held to the standard at the load port survey. And the buyer said, I'm totally happy with that, but I still have the right to bring this claim later. I'm not totally bound by the load port survey because the printed terms qualify that slightly. And this was something that the Court of Appeal explored. And the way that this trade was financed was essentially through a letter of credit. And there was a bank who, on production of documents, were going to release money to the seller. And if those documents were produced to the bank, then the bank was always going to release the money. And when they looked at it in that light, they said, well, actually, there's no value to this term. It doesn't do anything if it's said to be binding for invoicing purposes. The effect of being binding for invoicing purposes effectively means pay now, fight later. But in any case, because of the way that this trade was financed, you were always going to pay first and fight later. So the clause in the recap, if read in that qualified manner, actually doesn't have any effect. So the question for the court in practical terms is, does the recap term have effect, or does it have no effect? Does it have a effectively kind of illusory effect? I think the judge said. And I thought that was quite interesting.
Yeah, and sorry to jump in there, but the interpretation of the clause that the buyer is putting forward would, in this case, it would actually put it alongside the payment clause. It would actually mean that there's no binding certificate at all. It's effectively rendering what was specially agreed in the recap redundant. So you do actually have here the black and white scenario, coming back to Alexander and West Bromwich, where in that case, that was the case with Lord Justice Hamblin. And in that case, she was exploring the RWE Npower Bentley decision, which had one part of the contract requiring that the building be painted black and another part saying that it had to be painted white. I just thought that was such a neat example. And then they go, well, this is a clear example of a literal contradiction between clauses. But inconsistency is not limited to that. And then, refers to the Pagden decision as this concept of clauses not being fairly and sensibly read together. And here, that is clearly the case, that the two cannot be read together. At first blush, it doesn't look like a black and white scenario, but actually, when you look closely at what the buyer's interpretation would mean in this contract, in the context of this contract, it is actually almost a black and white scenario. there's this kind of pulls in the other concepts that are touched upon as well, albeit I don't think in this case it was decisive, because, as I say, the inconsistency when unpacked is actually clearer than maybe first thought. But those are the considerations of reasonableness and business common sense. And so it's approaching this question of inconsistency, having regard to what the business common sense is. It's not just a literal or a mechanical exercise. And the overall exercise, or what we're looking to see, is that printed term, is that general term transforming or negating the specially agreed term. And it's all of those concepts kind of being pulled together that I'm not as clear in setting it out as the decision, but I would very much recommend, if you have a case on this, to go to paragraph 28 of Lord Justice Mayall's decision, which walks you through step by step what to do here. And the last point I'd say on principle, Calum, before we kind of move to wrap things up, and any final thoughts that you've got, is the concept that if the specially agreed term is part of the main purpose of the contract, is it a central feature, if you like, of the contractual scheme? And that is another factor to consider. It's another relevant point in this analysis on inconsistency. So if the printed term is detracting from a key issue or a central feature, then it's likely to be inconsistent with it. And when you think about the provision in this case that we're talking about, whether a certificate is binding or not as to quality, that is an important feature. That's a very important feature, whether you have the ability to argue over quality after the event, or whether you're agreeing at the outset to a mechanism for determining quality.
Yeah, exactly. And I think that just from my side, I kind of maybe a couple of final thoughts is the first, as we've said, the key issue here is, do we have a conflict? Do we have a conflict between a contractual regime in the recap and a contractual regime in the printed terms? And I think that's dealt with as succinctly as possible by Lord Justice Mayall's, where he says, a regime in which a certificate of quality is binding is fundamentally different from one in which it is not. And I think that's really the bottom line on that question. And I enjoyed reading that sentence. I thought that's it's a pretty disappointing thing to read if you're on the wrong side of this one, but it's completely fair enough, and sometimes just stating it plainly is the right way to go. And then the second question that you kind of opened there is another interesting one, which is, to what extent are the courts giving credence in contractual interpretation to the commercial common sense of a contract? And I know that we have these high-level cases like Rainy Sky and Cookman Bank, where it's very much looking at the commercial intention, and that's kind of been paired back with a more literalistic approach with cases like Arnold and Britton. But even in those cases, they still say it is a key part of the process of understanding a contract and interpreting a contract, to look at it through a commercial lens. And I think that's really well done in this judgment too. He says this is a central term. It's a central feature of the agreed contractual scheme, and we've got to stand back and look at this in the context of the intention of the parties as practical business people going about their business, buying and selling these cargoes of oil. What were they trying to achieve by including in the recap the words "result to be binding"? Well, they were agreeing to be bound by the results of the load port survey, and giving effect to that. And the one final question that I'd maybe put to you as a final thought is, I wondered whether at the first instance there was a reluctance to suppress a claim that was otherwise quite straightforward, by the reliance on the load port survey that turned out not to be correct, or it appears to have turned out not to have been correct. Because even though the contractual terms taken in isolation give you a very clear result that the load port survey is to be binding, the effect of that term is actually extremely draconian on the buyer, because the buyer has bought a cargo which it turns out is outside the contractual specification, but they're bound by the survey, which it turns out may have been wrong. And I can see why the court would want to at least give the opportunity to the buyer to bring a claim.
Yeah, I can see that. I can see how, to the extent that, fact finders kind of can be swayed on some of these points by looking at the draconian effect. I can see how allowing a debate about whether this cargo was actually of good quality or not seems to be a fair thing to do. I don't know. I don't know whether that was really what was at play in the first instance. I tend to think not. I tend to think it was more around this concept of qualification or modification, the idea that, well, there's still a binding certificate. It's still being referenced in the printed terms. It's just having a more limited effect. And if you think about it in that way, I don't think it's right here, but if you think about another scenario where the recap is setting out a regime, let's say it is a certification regime or a testing regime, and then the printed term adds some additional requirements to that or qualifies it somehow, but doesn't do away with the whole regime, gives a bit more detail, that kind of scenario. You can see how in that scenario you could be much more in a qualification scenario.
Yeah, I agree with that. I think there's always a tendency, a very positive tendency, to seek to give effect to the entirety of a contract and not to say, well, that clause can't have any effect. There's the bias is almost, unless there's a really clear conflict, you try and give effect to every single part of the contract. Yeah, I do. That's right. The business common sense point, though, is important, and it does come through most certainly in this decision. If I can bring it back round full circle to one of the earlier points, I think that was almost most clearly driving this decision on where to start, on that question of how do we approach this question, where do we start the inquiry? We start it by looking at what the parties actually agreed for this trade. And from there, we then run it through this test and compare it to what's in the printed terms. And for me, that's a much more commercial approach. I don't think this decision, in answer to your question, fundamentally changes anything on the existing law. I think it pulls it all together and does a very good job, if I may say, at doing so. But on that point, this question of where to start, it may have shifted the inquiry somewhat, or focused the emphasis of the inquiry on the recap, on what's been specially agreed, and then everything else comes after that. And to the extent that you and I have both heard that, well, no, the Pagnan decision is kind of a principle that you look at it all as one contract, and it is one contract, but the inquiry we're conducting here is one of inconsistency and comparing two different terms within a contract and what's the priority and what's the approach that you undertake that. And to that extent, this decision, I think, clarifies how to go about it. And it's a really good decision if you ever have an inconsistency case. Yeah, exactly, which do pop up all the time.
They do. And we could take this conversation off onto other contract formation questions, which we see all the time, both in the US and in England, and the differences between the two jurisdictions. We've had quite a few on the go, actually, over the last year. So let's save that for another podcast. But it's a really fascinating area, and it's one of those areas for me that you've got what is happening there in real life between commercial parties on one side, and then what is the actual contractual framework and interpretation next to it, and how do we get those things working together? How do we make sense of it when the commercial parties are not typically looking at it from a legal perspective?
Yeah, agreed. Well, look forward to that conversation in due course.
All right, Calum, a good one. I've enjoyed today. Thank you for batting this one back and forth with me. Thank you to everyone who's listening in to our podcast. We're really delighted that you're listening. Thank you. We hope this is of interest, of some value for you and your practice, your business. And if you have any questions, if you'd like us to talk about any particular topics or any cases that you're aware of, just drop us a line. You can find our details quite easly on the Zyla Floyd Zadkovich website. And if I may ask, just a final point, if you're able to click subscribe or follow us on the podcast, we're on Spotify and on Apple Podcasts. That'd be great. And the weekly podcast will then drop straight into your feed on or about Thursdays every week. So thanks again. Until next time, take care.
Thanks, everybody. Goodbye.